Imagine you have had your green card for 6 years. You work full-time, you pay your taxes, your kids go to school here. You fly out to see your aging parents for what you think will be a normal 5-week visit. When you land back in the United States, you expect the same routine you have always known. Show your green card, answer a couple of quick questions, walk through. But this time, an officer pulls you aside. You are taken to a small room. 2 hours pass. Then 3. They are asking about an old, close criminal case from years ago, one you thought was long behind you. Nobody told you a single thing had changed. But something had. Here's what most people still do not realize. 2026 has quietly become one of the most difficult years in recent memory for green card holders to travel internationally and come back without a problem. Not because the green card itself changed, but because how it is treated at the border changed. And if you are a lawful permanent resident planning any trip abroad this year, there are several shifts you need to understand before. After this ruling, that has changed. CBP can now treat any returning green card holder as seeking admission, without needing that prior exception. In plain terms, that means an officer has more room to question your right to re-enter, even if you have lived here for years and never had a single issue before. This is where many people make a mistake. They assume a green card is permanent and untouchable. It is not automatically that. It is a status that can be reviewed, and this ruling widened the door for that review to happen right at the airport, right at the moment you are exhausted from a long flight and least prepared to defend yourself. The people facing the highest risk under this new standard are green card holders who have ever been convicted of a crime, even something that feels minor or long resolved. A plea deal. A reduced charge. A case that was dismissed. None of those outcomes automatically protect you anymore. Immigration law and criminal law use different definitions and different standards, so something your criminal attorney called a good outcome years ago might still carry weight with an immigration officer today. Most travelers do not realize this until it becomes a problem, sometimes years after the original case was already closed in their mind. If this applies to you, speaking with an immigration attorney before you travel is not just a nice idea. It could be the difference between a normal re-entry and losing your status altogether. Now let's talk about the second major shift, and this one affects almost every single green card holder, regardless of your record. Starting in late December of 2025, under a new Department of Homeland Security rule published in the Federal Register, CBP began photographing, and in many cases fingerprinting, every non-US citizen at every port of entry and every port of departure. That means this is not just happening when you come back into the country. It is happening when you leave too. Why does this matter for you? Because it means your travel history is now tracked with a level of precision that did not exist in the same way before. How many days you were gone? Where you went? How often you have been leaving and returning? All of that becomes part of a much clearer digital picture that an officer can pull up in seconds. This is not just a recommendation to be aware of. It is now standard federal procedure at ports of entry across the country. What this means practically is that vague answers do not work the way they used to. If an officer asks why you were abroad for as long as you were, having a clear, honest, documented answer matters more than ever. Keep records. Keep proof of your ties here, things like your lease or mortgage, your pay stubs, your tax filings, even something as simple as your utility bills. These small documents can carry real weight if you are ever questioned. Think of it this way. Your green card tells an officer what your status is. Your documents tell them why you still belong here. In 2026, you need both. Let's move to the third shift, and this is the one that catches families off guard the most, because it feels the least dramatic until it suddenly is not. It involves how long you are allowed to stay outside the United States before your green card itself is put at risk. Here is how the zones break down. If you are outside the United States for under 6 months, you are generally in a safer zone, though officers can still ask questions. Between roughly 180 days and 1 year abroad, you move into what many immigration attorneys now call a scrutiny zone. You are not automatically denied entry, but CBP officers can question you extensively about your intent to keep living here, your job, your home, your family ties. You need to be ready to show that your life is still rooted in the United States, not just visiting it occasionally. Then there is the danger zone. If you are outside the United States for a full year or more without something called a reentry permit, your green card alone is often not considered enough for reentry. A legal presumption of abandonment can apply. That means the government assumes you may have given up your residence here, and the burden shifts to you to prove otherwise. In that situation, CBP can refer your case to an immigration judge, and you could be paroled in temporarily while everything gets reviewed. In the most serious cases, absences of 2 years, this is not just a recommendation. This is federal immigration law that has existed for years, but it is being applied far more aggressively in 2026 than it was even 2 or 3 years ago. What used to be a quiet formality is now an active point of scrutiny. Let's pause here for a second, because I want this to feel practical, not just alarming. None of this means every long trip ends badly. It means every long trip now needs a plan. Now let's talk about something else that is shaping travel risk this year, even though it does not target green card holders directly. In December of 2025, the President signed Proclamation 10,998, which took effect on January 1, 2026. This order fully or partially restricts entry for nationals of 39 countries, expanding on an earlier order from the middle of 2025 that covered 19 countries. If you are a green card holder, you are technically exempt from this proclamation. Your lawful permanent resident status is not revoked by it. But here is the part that matters for you in real life. If you were born in, or hold citizenship from, one of these affected countries, immigration attorneys are widely reporting that green card holders connected to this list face extreme additional scrutiny at ports of entry, even though the ban does not legally apply to them. This is a case where being technically exempt on paper and being treated smoothly at the airport are two very different things. If your background connects you to one of these 39 countries, plan extra time for your return, carry extra documentation, and consider speaking with an immigration attorney before extended travel, even though the law itself says you should be fine. What happens next surprises a lot of people, because officers at the border are working under expanded vetting guidance that goes beyond what the written law technically requires of a green card holder. There is also a broader trend worth understanding, because it explains why all of this is happening at once. Immigration authorities have been steadily tightening enforcement since 2025, driven by three connected forces. First, national security has been placed at the center of the current administration's immigration agenda, which means border vetting has become a higher priority across nearly every agency. Second, there is growing government attention on whether green card holders are genuinely maintaining their lives in the United States, or effectively living abroad while keeping the benefits of permanent residency on paper. Third, advances in digital tracking and biometric technology now make it far easier for the government to actually enforce rules that, in past years, were difficult to monitor consistently. Put simply, the rules themselves are not entirely new. What is new is how closely they are now being watched and enforced. So let's talk about what you can actually do, because information without action does not protect you. This is not just a recommendation. In some cases, these are legal steps that carry real weight if you ever face questioning. First, if you know you will be outside the United States for more than 6 months, file Form I-131, the application for travel document, well before you leave. This is your re-entry permit, and it can protect you from the presumption of abandonment for up to 2 years. Do not wait until you are already abroad to think about this. It should be filed while you are still in the United States, and processing takes time, so plan months ahead, not weeks. Second, Keep your address updated with USCIS within 10 days of any move. It sounds like a small administrative detail, but failing to do this can delay important notices, complicate your record, and make you look less consistent if your ties to the country are ever questioned. Third, build what many immigration attorneys now call a ties packet. This means gathering proof of your continued life here before you even leave. Tax filings for the last few years. Recent pay stubs or proof of employment. A lease or mortgage statement. Utility bills in your name. School enrollment records if you have children here. Keep digital copies on your phone and physical copies in your bag when you travel. If you are ever pulled into secondary inspection, being able to calmly hand over real proof changes the entire tone of that conversation. Fourth, if you have any past criminal history, even something you consider closed and fully resolved, talk to an immigration attorney before you travel, not after you are already standing in a secondary inspection room. A short consultation beforehand is almost always far less stressful, and far less expensive, than trying to fix a problem after you have already been stopped at the border. Fifth, if your travel connects you to one of the 39 restricted countries under Proclamation 10,998, even indirectly through dual citizenship or your place of birth, treat your trip with extra caution. Confirm your documents are current, keep your green card and any re-entry permit easily accessible, and consider legal guidance before you go, even though your status as a permanent resident is technically protected. And sixth, for many long-term green card holders, immigration attorneys are increasingly pointing to one long-term solution above all others. Naturalization. Once you become a U.S. citizen, the entire risk of abandonment, the scrutiny zones, the presumption of seeking admission, all of it disappears, because citizenship is not something that can be questioned at the border the way permanent residency can. If you are eligible and you travel frequently, this is worth seriously considering, not as a reaction to fear, but as a long-term form of protection for your family. Before we get to real-life examples, let's also talk about dual nationals, because this is a group that often gets confused by these rules. If you are a green card holder who also holds citizenship in one of the 39 restricted countries, but you also carry a passport from a country that is not on that list, the exceptions under Proclamation 10,998 generally follow the passport you are traveling on, not simply your place of birth. This does not eliminate scrutiny, especially if your records show ties to a restricted nation, but it is an important distinction that many families overlook. If this applies to you, keep both passports current, and be ready to explain your citizenship situation clearly and calmly if you are asked. It is also worth mentioning what TSA, that's the Transportation Security Administration, expects from you before you even reach the CBP officer on your way back into the country. Make sure your green card is not expired, and if it is close to expiring, renew it well before you travel, because a green card nearing its 10-year expiration date can add unnecessary friction, even though your underlying status does not disappear the moment the card itself expires. Many travelers also assume that a driver's license alone is enough identification when re-entering the country. It is not a substitute for your green card. Carry the physical card itself, not just a photo of it on your phone, and keep it somewhere accessible, not buried at the bottom of a checked bag. One more overlooked detail. If you have applied for U.S. citizenship and your naturalization case is still pending when you travel, extended time abroad can actually complicate that pending application, because continuous residence requirements for naturalization are separate from the requirements that protect your green card itself. If your citizenship interview or oath ceremony is approaching, or if you have a case actively in progress, this is another strong reason to speak with an immigration attorney before committing to a long trip, so one process does not accidentally interfere with the other. Let's talk briefly about what this looks like for a real family, because numbers and rules can feel abstract until you see how they connect. Picture a green card holder who travels home for 2 months every year to help care for an elderly parent. On its own, 2 months is well within the safer zone. No real risk there. But now picture that same person also has a decade-old dismissed charge from their 20s, and their country of origin happens to be on the restricted list from Proclamation 10,998. None of those three facts alone is disqualifying. But together, they combine into exactly the kind of profile that now draws extended secondary inspection. This is why understanding your full picture matters more than just memorizing one rule in isolation. Let's also clear up a few common misunderstandings, because misinformation spreads fast on this topic. Having a green card does not mean you are protected the same way a citizen is. It never has, but the gap between the two has become more visible in 2026. A short vacation of 2 or 3 weeks is not what any of these rules are targeting. The real risk builds with extended absences, past criminal history, or a connection to heightened security screening. And simply being nervous or unsure of a question at the border is not, by itself, dangerous. What matters is having real documentation ready, not a perfect performance. Let's bring everything together with a fast recap. The Supreme Court's Blanche v. Lau decision means CBP can now treat any returning green card holder as seeking admission, which raises real risk for anyone with a past conviction, even an old or resolved one. Biometric photographing and fingerprinting now happens at every entry and every exit, meaning your travel patterns are tracked more closely than at any point before. The timeline for how long you can stay abroad has become far less forgiving, with real scrutiny building after 180 days and severe consequences after 1 year without a re-entry permit. Proclamation 10,998 does not legally strip green card holders of their status, but it has clearly increased scrutiny for anyone connected to the 39 affected countries. And the practical protections that matter most are a re-entry permit for long trips, updated address records, a strong ties packet, legal guidance if you have any criminal history, and for many long-term residents, a serious look at naturalization. None of this means you cannot travel. Millions of green card holders still fly abroad and come home without any issue at all, every single week. But 2026 is simply not a year to travel on assumptions from 5 or 10 years ago. The rules around you have shifted, even if your daily life has not, and the difference between a smooth return and a stressful one often comes down to how prepared you were before you ever boarded that first flight. If you take one thing away from this video, let it be this. Stay informed through official sources like USCIS and CBP directly, not just rumors you hear secondhand or stories passed around in group chats. If you have any doubt about your specific situation, especially if it involves a past criminal record, an extended trip, or a connection to a restricted country, a short consultation with an immigration attorney before you book your flight is almost always worth it. If someone in your life holds a green card, a parent, a sibling, a coworker, a friend, share this video with them today. This is exactly the kind of information that can quietly protect someone's entire future here, and most people simply do not hear about these changes until it is already too late. And if you want to stay ahead of changes like this before they catch you off guard, subscribe to this channel right now, because we will keep breaking down exactly what is changing in immigration policy, and exactly what practical steps you need to take to protect your status, your family, and your future in the United States.